All right, well, thank you very much for coming. It's very exciting to present on behalf of the ICN Steering Group our draft report, Competition Law Enforcement at the Intersection between Competition and Privacy. So what our draft report does is it looks at the intersection between privacy and competition. And this was a subject that you've heard already repeatedly this morning. And Part 1 of our draft report looks at 4 potential areas of intersection. So the first category is one that you invariably deal with on a day-to-day basis, that privacy and competition really have no intersection with each other. So for example, your price-fixing cartel is unlikely going to raise any privacy issues. And then for those of you that also have a privacy obligations, there may be privacy cases which have no competition issues whatsoever. The second category is where most of you are currently. There is an intersection between privacy and competition, and they're complementary. So the thinking here is that increasing competition will increase privacy. And you've heard already some of the instances today. No doubt you've had experiences with that with your agency. And we're going to hear as well from Andreas about exploitative abuses of dominance, how that could fall within the secondary category. And you also have other cases. There could be, for example, data-driven mergers that might help firms attain a monopoly position or help them obtain a monopoly in a new market. There are also mergers that might eliminate a nascent competitive threat that's offering better privacy protections. And we discuss in the secondary category how privacy and competition, when they're complementary, can offer you then additional tools as well. For example, market definition and designing remedies. So now we come then to the third category, and this one is interesting. It might be a bit of a twist for you. Here, an increase in competition will not necessarily increase privacy. In fact, increasing competition can actually reduce privacy. Now, this might seem counterintuitive, right? Because we always believe that competition is good. And if we increase competition, we're going to get a better result. The problem, though, is when incentives are misaligned. And when incentives are misaligned, you can then have what's called a race to the bottom, an arms race, where data is collected about us, but not necessarily for our benefit. And there are many examples when you can have this market failure. One form where incentives might be misaligned involves behavioral advertising, but there can be others as well. So as a policy measure in this third group, it requires you then to identify what's the source of the market failure. And it might require, for example, better guardrails, better privacy guardrails in order to steer the competition in a way that it's a race to the top. And you've heard it already before about dark patterns. You might have consumer protection issues as well. Now, the fourth category, privacy and competition still conflict. Here, let's assume that the incentives are aligned. Let's also assume that competition is a race to the top. Nonetheless, you will confront areas where privacy and competition still conflict. This could arise, for example, in designing antitrust remedies. It might be the case where rivals might want access to data. That will increase competition, but it can also then impede privacy. You can also have, and I think John is going to speak about this maybe, about privacy policies that may favor entrenched firms and deter entry precisely because they're so onerous and so costly as a result. Or you can have simply a jurisdiction that has very stringent privacy protections that encourage data minimization, and then that could run counter to the competition policies which seek to promote the flow of data precisely because data can be non-rivalrous and can benefit others. So once we have then these four categories, part two then looks at a checklist of issues and questions for you to address across the types of cases that you run across. And this checklist is meant to be helpful in just providing you and your staff a way to look at these issues. So first, is there an intersection? Second, if there is an intersection, which of the four categories does it fall in? Is privacy and competition in this industry complementary? If competition exists but privacy weak, is this a market failure in the terms of abuse of dominance, or is this the function of incentives being misaligned? And then third, if incentives are aligned and there are adequate privacy guardrails in place, and privacy and competition are in conflict, then you need to ask yourself, is this conflict genuine or is it pretextual? Because you can imagine firms might use privacy as a pretext for anti-competitive actions. And then finally, if there is a conflict, incentives are aligned, and this conflict is non-pretextual, the issue then comes to who should decide this trade-off and how? And the answer can depend upon your jurisdiction. It might be your agency, it might be the courts, it might be the legislature, it might be someone else. And we recognize that not every jurisdiction is going to look at this the same. Some jurisdictions might value competition more than privacy. Others may look at it differently. So we can't provide a ready answer because your jurisdiction may look at this issue differently. But what the report tries to do then is to provide a framework for you to assess these trade-offs when privacy and competition actually conflict. The first thing we offer is avoiding several traps. One trap is to reflexively assume that let's go with competition. If we're in doubt, let's go for competition, because competition may not be helpful when it is a race to the bottom. Moreover, it may not be reflexively going for privacy always, because that can then have significant costs on society as well as well-being on citizens. We also offer several rule of law objectives. Whatever your standard might be when there is this trade-off between privacy and competition, it should be transparent, should be objective, it should be predictable as well. There's another interesting way to look at this. What you'll likely hear is, can't we have it both? Can't we have competition and privacy? And the way to look at it is, I have this smart watch which provides amazing data. And you can imagine the data from my watch could be used by so many different agencies, as well as the medical insights that it could provide. I mean, think about it. All of the data about my heart rate, the number of steps, my activities, just think what this could do with medicine. So you will then invariably confronted with the issue is, let's get this data into the hands of other agencies. Let's get this data into the hands of these innovative startups and think about the insights that can arise. But then there are going to be significant privacy issues as well. So you will then be confronted with, well, can't we give the data to many competitors and then anonymize the data? The problem, as you well know, is the risk of re-identification of the data. And what we've heard already, some of the agencies, even the largest agency, they're resource constrained. And they don't have the wherewithal to come up with ways to successfully de-identify data. But one thing that the competition agencies can do is increase the incentives for others to de-identify data. And then we also discuss the use of market studies as a tool. And then finally, we conclude with interagency coordination models. One common theme is that the internet has no borders. And one agency cannot shoulder the burden, right? I mean, we're going to hear about the wonderful things that are happening in India and Germany, but we can't then impose that on one agency. And it's not going to help necessarily the citizens in your jurisdiction either. So there needs to then be cooperation on at least two levels. First, cooperation internally within your jurisdiction with the privacy officials as well as consumer protection. And then second, cooperation among jurisdictions. So this is where we are right now. We've drafted this report, and I would like to get for you three things. The first would be, we would be very interested in your jurisdiction's experience where privacy and competition intersect. So we would love to get more cases because that will then help the report. And when you have cases, please let us know in which of the four categories did it fall in. If there was a tension, how was that tension resolved? Second, are there any issues that the draft report doesn't cover that it should cover? And third, any other feedback? So we're going to have at 4 p.m. another breakout session on this topic. But in the interim, you can reach out to any of the members of the steering commission. You could reach out to Maria, Cynthia, Paul at the FTC, or you could reach out to me, and we would love to get your feedback. So now we're going to turn it over to Andreas for his experience with the intersection between privacy and competition. Andreas.
Yes, thank you very much, Maurice. I will try to make it a bit more practical for everyone to see where are the issues with regard to the intersection between competition law and privacy. First of all, let me say it is astonishing that we in the ICN have gone such a long way in such a short period of time. Because I can still remember when we presented the idea in the steering group that we should have an intersection project, intersection between competition law, privacy, and consumer protection law, and that there was great resistance in the steering group from some agencies at least, saying that has nothing to do with each other. Let's stick to competition and let us not talk about other issues of which we do not understand very much. That is some years ago, and today we sit here on a panel, and I think there is no one in this room who would say today that competition and privacy have nothing to do with each other. So that's my first preliminary remark. Another very short preliminary remark is that the intersection between competition and other areas of law is not that new. I mean, we are all dealing as competition agencies, even if we are not regulators, we are dealing with regulatory matters. We are dealing with postal issues, electricity, and we always have to take into account what happens on the regulatory market here. We are dealing in Germany with waste management, and I can say that the Federal Cartel Office is one of the key advisors how to make waste management systems more competitive. And here we have to deal with waste management matters to a depth that I would never have dreamt of. So you see, it's not completely new. But to come back to privacy, it is very clear that, and the digital markets have put that on the table, if you want to deal with the question of data-driven markets, you have to deal with data. And if you have to deal with data, you have to deal with privacy matters. That is quite obvious. And I think to make it practical, the key case, one of the mother of all cases with regard to that, at least for the Federal Cartel Office, was the Meta case that we have decided in 2019, where we have done exactly that. We have looked at the gathering and the processing of data by Facebook by then. And we wondered, how do we assess this collection and this processing of data? Do we develop our own parameter in order to do so? Or do we look at a parameter that is already in place and that the legislator has already granted? And if you take it like that, you very quickly come to the European GDPR, the General Directive on the Regulation of Data. And we took the decision that this should be our parameter. If you do this, you have to assess if the gathering, the processing of data is in line with GDPR. And here again, you dive into a field of law as a competition agency that does not go without saying, because in the very end, we are competition people. We know something about competition law, about competition economics, but we are not the ones to decide on data matters. So we had to dive into this area in the Facebook case from two directions. We looked at data first from the viewpoint of to enforce the users of Facebook to provide limitless data from the user, if this could be an exploitative abuse of the user. That was point one of our assessment. The second one was the data that was gathered and processed by Facebook was not in the hands of the competitors. So that could be a competitive disadvantage of the competitors of Facebook. So these were the two issues we looked at. And we looked at it in a decision of 300 pages, and 100 pages out of these 300 pages were not about competition law, they were about privacy law. And did Facebook gather and process the data in line with privacy regulation? You know, the end of this case, we came to the conclusion that it was not in line with GDPR. And having said that, we prohibited to Facebook to gather the data limitless, to process it limitless, if the user does not agree to that. And if the user does not agree to this limitless collection, he shall still be able to make use of Facebook. That is the core of our decision. That was decided in 2019, and from there this case went into an endless saga before courts, where it is still. Very important for us, the decision of the Federal Supreme Court in Germany, which confirmed our decision, but from a different angle. It said that privacy issues can play a role in assessing dominance and in assessing an exploitative abuse, but it did not go into the depth of this question. It did not go into the depth of our decision here. It just said, quite simple in a certain way, well, since Facebook does not give a choice to the consumer, and since Facebook is dominant, that is an abuse, not giving a choice. So it did not plunge that deeply into privacy matters. It was about choice. I'm not talking about the rest of the saga. The next stage of the case was the European Court of Justice, who has just recently decided, and that is, I think, very important, and that is very much in line with our decision and backs and supports our decision, that competition agencies may take data protection rules into consideration when weighing interests in decisions under competition law. And the European Court of Justice went even further in saying this might even be necessary. So it is nothing that we can choose to do, it is something that we have to do, because excluding data protection rules would disregard economic reality, and this would be liable to undermine the effectiveness of competition law. I think that is, in a nutshell, the three key sentences from the European Court of Justice. And I think this opens a new field for competition agencies, because we are no longer talking about an innovative theory of harm. We are no longer talking about, are you allowed to do that? Is that your field of law as a competition agency? How can you apply data protection law as a competition agency? We have to assess this. Unsurprisingly, the ECJ also said you have to cooperate with data protection agencies because you are not a data protection agency. A bit difficult in Germany, we have 17 data protection agencies at the level of the Länder. We reached out to them. We even reached out to the Irish Data Protection Agency with regard to Facebook. So to conclude, what started maybe as an innovative and some said experimental approach, today in a way is common sense. I remember 2019, when we had just issued the decision. I was traveling around in the US a bit on the occasion of the ABA spring meeting. We discussed that with US lawyers, our colleagues from US agencies, and what I heard was mainly, Andreas, I don't really understand, I don't even understand what you are talking about. I mean, this is not competition law. And I'm very happy that today, what I say here on this panel, first, is common sense. Secondly, it is reflected in Section 19A, the special provision that we have in Germany on digital markets. And third, it is reflected even in the DMA, Article 5.2, which says, gatekeepers shall not combine or cross-use personal data between designated core platform services and other services unless the end user has been presented with a specific choice and has given consent. So, this is what I mean by saying we have gone a long way in a pretty short period of time, because the case dates back to 2019. It's far from being decided by the courts, finally, by the way. But maybe the key thing here is you find it in the law today at the German level, at the European level. And I think this is the key message, that we are on the right track. And maybe this is also a call on competition agencies worldwide. Be innovative, try it out. You might lose your case, but maybe you win it. And maybe you even are able to write kind of history of law. It takes a while, but it can work. And I think that is the key message that you can draw from this very practical approach on the question of how competition law and privacy relates.
Thank you very much, Andreas. Now let's hear the exciting things that are going on in India. Ravi.
Thank you, Maurice. First of all, I would like to compliment ICN for the handbook on competition law enforcement at the intersection between competition and privacy. I think it's very useful. The categorization that it has done of competition and privacy into 4 categories, and the checklist that has been drawn up are very useful and would come in handy. Coming to the Indian experience, we've had a very interesting experience. In 2021, WhatsApp came with a policy with regard to terms and conditions for usage of WhatsApp by various customers, users. The policy very clearly said that you would have to give your consent if you want to continue to use WhatsApp. Otherwise, you would not be on the WhatsApp groups. So the Commission looked into this matter and said, well, this is take or leave it. Take it or leave it. So this is really something which is violative of the privacy guidelines. You're not giving option of consent, which is an actual consent. Very soon, within 2 months of our decision, where the Competition Commission said that we would need an investigation to be done, WhatsApp was before the Delhi High Court. So they said this is not something which the Competition Commission can look into. They have no jurisdiction to look at these matters because there is a separate data protection agency, and in addition, the matter is already pending before the Supreme Court. So what had happened is that some parties had gone to the Supreme Court indicating that this provision, which was a part of the WhatsApp policy, is violative of Indian citizens' right to privacy under the Constitution. So they had constitutionally challenged the matter. The single judge of the Delhi High Court dismissed the matter, saying the CCI, which is the Competition Commission of India, can look into it. They very soon went into the double bench of the Delhi High Court, which again dismissed the matter. And ultimately, it went before the Supreme Court of India. So the challenge was very clear that the Competition Commission does not have anything to do with privacy matters, and this matter is already before the Supreme Court. So the Competition Commission does not have any jurisdiction. We're very fortunate, in fact, the Supreme Court took it up out of turn and said very clearly that the decision of the Competition Commission is not without jurisdiction, and they are empowered under the Competition Act to look at these matters as well, and the investigation should proceed. So that was a very important decision for us, and this happened last year. So about a year, it took us close to nearly 2 years for the matter to be decided. But now we are at a stage where this matter is being looked at by the Competition Commission. Another related development which I would like to share with regard to the Indian experience is that we recently had a Digital Personal Data Protection Act which has been passed by the Parliament. Maurice was referring to, where the intersection happens. So will it be the legislature or the judiciary or the regulators who will come into the picture? So in that connection, the Indian Parliament has also been quite active on this aspect. And we have a very detailed Personal Data Protection Act. The Act provides for the manner in which data will be collected, its storage, its processing, and the sharing of data. So there is a clear provision that data fiduciaries would have to be responsible, and they would have to obtain the consent of the data principals with regard to the usage of data. This is a very recent development, so there have been demands from the industry that it is going to take us time to comply with it. So there is a provision for a data protection board to be set up, and so far the government has been very clear that we would like to give time to the industry to come on board. Especially because in a lot of cases, the issue which was being raised was that we are not really conscious of the kind of data we are collecting, and the third parties may be processing it in ways that we are not aware of. So the government has clearly indicated that we'll give you time. You undertake an audit of what you are doing with the data, what is the kind of data you're collecting, and how are you processing it and sharing it with third parties. So this is another related development which has happened on the data protection front from the Indian side. Of course, we as the Competition Commission will continue to look at privacy issues. And for us, a very important aspect is the intersection. Where does the intersection happen? Because what's happening is, in the case of India, it is one of the largest markets with regard to digital landscape. So far, it's the second largest market of the world. So we're very conscious of this fact that, companies are coming to India. They would like to have more and more users, visitors. However, what exactly is being done with the data is something that the government and the regulators and agencies need to look at. So it's a very interesting time, and of course we are having some other matters also which are pending with regard to other platforms. There is of course, in the case of people who are already adhering to or complying with the GDPR, the government has said that, the timelines will be shorter for you because you are already aware of what are the requirements, and a lot of these global companies may also be aware of them. The third area where we are also looking at in the digital space is ex-ante regulation, and how that comes into play with regard to digital markets. So the DMA is, of course, a guide for all of us. We are looking at the DMA, and the Indian Parliament committee has said that let us look at the requirement. Do we need to have ex-ante regulation? And if so, what should be its nature? Of course, we have a very robust startup ecosystem. So the concern is that we should not be stifling innovation and being hasty in whatever regulation we undertake. So there is a digital competition law committee which has been set up. The Competition Commission of India is part of that. So we are also contributing to that discussion, and the matter is being considered. So there is a very delicate balance which all along the various agencies of government, the government and the parliament and the various other sectoral regulators are trying to ensure is that we do encourage people to come to the Indian digital market, to foster innovation, to enable the startups and app developers to be able to come forward with newer applications, while at the same time we be careful that the large big tech companies and platforms do not create problems in terms of anti-competitive practices being undertaken by them or abuse of dominance happening on their part. So we at the Competition Commission are quite active, and I'm sure this handbook will be very useful for us. Thank you.
Thank you very much, Ratni. John.
Thank you very much. It's great that ICN is doing this. I'm pleased to say I was involved at the very start of the project when you were trying to push it over the line on Andreas, and ICN should be doing cutting-edge issues like this. At a high level, this is interesting because there's a paradox. If you talk to one set of people, they'll be obsessed with the microphone has gone. It's back? Yeah. Talk to one set of people, they're concerned with the ubiquity of data, the data that my watch, my phone, my ring, whatever collects, and it's everywhere, and there's an awful lot of it. And then you talk to another set of people, and they're concerned with the scarcity of data, the exclusive use of it. And so there's something quite interesting in the intersection between something where we're simultaneously concerned with abundance and with scarcity. I think this paper is a very useful step forward. It's very good to see clear and explicit recognition that there are trade-offs between competition and privacy. It's very good to have the case studies and example. But I think, in my view, the paper needs to go a bit further and deeper. And so I thought I would set out 3 things that I think a paper like this probably needs to have. And one is a very clear and strong framework for how markets and incentives work. The second is a level of generality that applies to competitive markets and not just markets with dominant firms or dominant platforms, because these trade-offs and issues arise in banking, insurance, grocery retail, and many other areas. And then thirdly, I do think it needs to be open-minded and evidence-based, not making assumptions on what's harmful without looking at the cases. So on the first point, the framework, we have a very clear framework, I think, for considering complementarity and conflict between consumer protection and competition. We know that competition is probably the first line of defense for consumer protection. Competition delivers very good outcomes for consumers. But we also know it's not sufficient. We know that in competitive markets you can have deceptive practices. I took cases against airlines, supermarkets, many other industries that were highly competitive. And the more competitive they were, the more it seemed that consumer protection was important in those sectors. And I think this insight might be true for privacy too, that we really need to be concerned with privacy practices in more competitive markets where some of these deceptive practices may arise. I think one of the problems of the paper is its starting position is that this happens primarily with dominant firms and tech platforms, and I'm not denying that it does. But if you begin your analysis by thinking about excessive collection of data as analogous to excessive pricing, does that give you the framework to think about excessive data collection by an airline in a competitive situation? I don't think it does. I don't think I would describe that as excessive exploitative pricing of a market power type. I would think of it as closer to deceptive advertising or some other practice. So I think that starting with understanding how these issues arise in competitive markets and then moving on and looking at how they interact with market power is an important thing to get right in this paper before we just focus on the dominant issues. And to give you one example of that in the paper talks about dominant firms using dark patterns and choice architecture to nudge users to opt for less privacy-friendly options, and cites an FTC paper. But then I went and read the FTC paper, but the FTC paper is about largely quite competitive markets, not about dominant firms. So I don't think you should preface everything with dominant firms in this paper, because this is an intersection project, not a unilateral working group project. This is going to be really important going forward, because all of these other markets, insurance, supermarkets, banking, they've spent the last 20 years digitizing information, but they haven't managed to use it. And AI is going to enable them to use it. So in Andreas's language, a lot more markets are going to be data-driven, and competition authorities are going to have to face these issues in many more markets than just the tech platforms. And there are clearly insights from the tech platforms, but I think we need agencies to be prepared to do this. So I think the paper does a good job on trying to set out the complementarity in both directions. Competition can harm or improve privacy. Privacy can harm or improve competition. I do think it's important that the paper covers not just cases and mergers, enforcement cases and mergers by competition authorities, but also competition enforcement, competition advocacy. Because if I look back at GDPR, I think GDPR probably had a detriment. There's evidence that it had a detrimental effect on competition. Big tech companies had close to zero costs of implementing GDPR. Big companies that were not tech companies had big costs of doing it. SMEs had even bigger costs. So GDPR had an adverse effect on competition. I don't think competition authorities were in a position maybe to point that out in advance. But as governments think about introducing new privacy policy, it's very useful to understand how privacy policy might distort competition and to think about advocacy in that area. My third theme is just about having an open mind. The paper has a very heavy focus on a few issues that it thinks are bad, and one of them is targeted advertising. It sort of seems to take the position that targeted advertising is bad. Now, there is an alternative view that targeted advertising is quite an efficient innovation in the economy that brings down advertising costs. And the paper does say, for some advertising, it might be more cost-effective in driving sales than contextual ads. This feels like an understatement, particularly as it's followed by a very long list of the harms from targeted advertising and behavioral advertising, and it says, and its underlying surveillance. Now, personally, if I go online and I search for a fridge freezer and other websites offer me fridge freezers and maybe offer them at better prices, that's slightly better maybe than magazines advertising cars to me when I'm looking for a fridge freezer. So there may be efficiencies here, and we shouldn't throw them out. We need to balance them. And it's also, there's a risk. It talks about manipulating consumers, and it says, it talks about exploiting and degrading consumers' privacy and manipulating their choices. But there's a risk here that we fail to look at other things that do that. And so I would be interested in looking also at cases where, like the New York Times exit fees from contracts, where personal data and privacy is used as a reason for companies to stop consumers moving to a rival platform. We've developed open banking in the UK precisely to get around that problem, to drive increased competition in banking. And then I think some of the talking about guardrails to limit targeted advertising and encouraging consumers to opt in, there is a risk that consumers may not opt in for reasons other than privacy. So one final point is that I do think the focus in the paper necessarily, because that's where the cases are, is very much on advanced economies. And I think, Maurice, you said at the start, it would be very good to get examples from people here. But I think for ICN, it's incredibly important that the issues in developing and newly industrializing economies and what challenges they're facing in this space are examples that we can also cover in this paper. And I very much welcome that, because they're very different environments. We have 100 countries here, and I think the examples in the paper come from a handful so far. And so it'd be really good to understand those issues. So in summary, it's great that ICN is doing this. I do think we need a stronger underlying framework of how it applies in competitive markets. We need to avoid making assumptions that certain things are bad just because we've observed them as bad in the context of dominant platforms. And I think we need to make sure that this is properly an intersection project and not a unilateral conduct workshop, unilateral conduct project, because it sometimes feels more like that than an intersection project. But so I'm a big fan of this, but would encourage you to improve it. Thank you.
All right. Well, thank you so much, John. And we'll continue this debate at 4 o'clock this afternoon with the breakout session. And no doubt, many of you have your thoughts about the pros and cons of behavioral advertising and some of the harms that it arises. But I want to join me in thanking the other panelists for their wonderful remarks, and I look very much forward to getting feedback from you. Thank you.